there might be some witnesses in the courtroom who are here pursuant to a subpoena or who may otherwise be in the courtroom. There's a sequestration order agreed to by counsel, which means that all witnesses need to wait outside the courtroom until they are through testifying, and that's to guard against anyone just listening to testimony and then being influenced concerning their own testimony, either subconsciously or otherwise. And I believe, at least earlier this morning, there were some people here who are here pursuant to a subpoena. If you are, or if you think there's any chance that you might be a witness, then you need to wait outside the courtroom until you're called to testify. Once you're through testifying, I'll ask both sides if you may be excused finally, and if you are, that means you can remain in the courtroom, you can leave, whatever you want to do, but just do not discuss your testimony with anybody until the trial is finished. Any questions about that? I don't see any. So any of you who are here pursuant to a subpoena or otherwise think that they may be a witness, then I'm going to ask you to leave right now before we bring the jury. Okay, so I don't see anyone, so I guess everyone has left already. Counsel, anything we need to put on the record before we bring in the jury?
No, Your Honor.
No, Your Honor.
Okay.
All rise for the jury.
Morning, ladies and gentlemen. Everyone can be seated. The jury can remain standing. I'm sorry for a second while the clerk in this is.
Members of the jury, please raise your right hands. Do you and each of you solemnly swear or affirm that in all causes committed to you, you will give a true verdict therein according to the law and the evidence given you?
I do.
Members of the jury, hearken to an indictment in the matter of State of Maine versus John Williams charging intentional or knowing murder, 17A Maine Revised Statutes, subsection 201, 1A, and 1252, sub 5. On or about April 25th, 2018, in Somerset County, State of Maine, John D. Williams, date of birth 7/11/88, did, with the use of a firearm, namely a Ruger 9mm handgun, serial number 317-65479, intentionally or knowingly caused the death of Eugene Cole, date of birth 10/7/56, all in violation of 17A Maine Revised Statute, section 201, 1A, and 1252, sub 5. On this indictment, the defendant has been arraigned, and upon his arraignment has pleaded not guilty, and for trial, the defendant has put himself upon this country, which country you are. You are now sworn to well and truly try the issue. If you find the defendant guilty, you will say so. If you find the defendant not guilty, you say so and no more. Members of the jury, hearken to your evidence.
Please be seated. All right, good morning again, ladies and gentlemen of the jury. I hope you enjoyed the weekend. Before we start today, I just want to check with just a show of hands. Could you please indicate to me if, despite your best efforts, anybody on the jury had any contact with newspaper, radio, television, or other internet or social media accounts of the trial? I see no affirmative responses. Thank you. All right, ladies and gentlemen, you just heard the clerk read the indictment. And I'm going to give you a few initial instructions before the trial starts. First of all, although the clerk has just read you the indictment, I want to remind you that the defendant is presumed to be innocent, and that presumption stays with him throughout the trial. The indictment merely states the charges. The defendant can only be convicted of the charge if the state proves and you find, beyond a reasonable doubt, that the defendant is guilty based solely on the evidence and testimony presented at trial. The indictment is not evidence and cannot be given any weight whatsoever in deciding whether the state has met its burden. You, as the jury, are the deciders of fact. As the judge, I will administer the proceedings and make rulings on the law, but you and you alone are the ultimate decision makers as to the facts. It is important that you see and hear all of the evidence and arguments that are presented during the trial. So if at any point you cannot hear a witness or an attorney or myself, or if you cannot see something that's being presented or discussed, please raise your hand as soon as possible so we can take care of the problem. In this connection, witnesses are sometimes shown documents or objects to refresh their recollections, but the documents themselves or the objects are not admissible or not going to be offered into evidence. So you should listen carefully to the testimony and not assume that you'll later get a chance to read every document or look at every object that is presented to a witness. During the course of this trial, those jurors who desire to do so will be allowed to take notes. And we're going to take a break at the end of the opening statements, in part in order to get those notebooks out for you. You may or may not take notes as you wish. Whether you choose to supplement your observations and recollections by note-taking, or whether you choose to rely solely on your observations and recollections as the basis for your deliberations, either choice is appropriate. The views of jurors who have and who have not taken notes are entitled to equal consideration in your deliberations. If you elect to take notes, there are some rules that I'm going to ask you to follow. First of all, do not allow note-taking to distract you from paying attention to the evidence as it is being presented. You must carefully evaluate the testimony of each witness. To do so, you must observe the witness. Note-taking must not distract you from such observation. Take notes sparingly. Do not try to summarize all the testimony because that may distract you from important observation of the witnesses. The notes should be taken in notebooks supplied by the court officers. Notes should not be made by any other means. Particularly, notes should not be taken during using smartphones, or any other electronic devices. During recesses, just leave your notebook right in the chair, and they'll be collected and kept confidential. They'll be returned, obviously, to you on resumption of the trial. You should not disclose the contents of your notes to anyone except during your deliberations with your fellow jurors. You may use your notes in the course of jury deliberations. At the end of jury deliberations, your notebooks and any other written materials used in deliberations must be turned over to the jury officers. To protect the confidentiality of your deliberative process, the notes will be destroyed after the verdict is announced. Your notes are not a substitute for the verbatim record. They exist only to assist your recollection of the evidence. They should not be used to prove that your recollection of the evidence is superior to that of another juror who may have elected not to take notes. Note-taking does not have precedence over independent recollection of evidence. As indicated earlier, all of you will discuss the case as equals in jury deliberations. Your views are entitled to equal consideration, whether you have elected to take notes to support your recollection or whether you have elected to rely only on your recollections and observations as the basis for your deliberations. In addition, you must not attempt to take notes about the case during the course of recesses or when you leave the court at the end of the day. Such note-taking outside of the courtroom may raise a risk that matters occurring outside of the courtroom could affect your deliberations. The risk of such outside influences must be avoided at all costs. Accordingly, while in good faith you may believe it helpful to take notes to aid your recollection, you must not make notes regarding these proceedings during recesses. Please keep an open mind until all the evidence is in. Remember that the last witness may be just as important as the first. That's one of the reasons that you must not discuss the case, even amongst yourselves, until all the evidence has been presented, until you've heard the closing arguments of counsel, until you've been instructed on the law by myself, and until I send you back to the jury room to begin your deliberations. Juror 93, you are the foreman in this case. We'll go into that in a little more detail, but I don't believe I told you last week, so I want to let you know that you're the foreperson. I'll remind you several times during the trial that you're not to speak with anyone, including other jurors, about the case. Probably to the point where it sounds like a broken record, but it's simply so important, and that's why I'm going to tell you that every time we take a break. And as I said, in the unlikely event that someone tries to speak to you about the case, report that attempt immediately to a court officer, and we'll take care of it. In addition to the general instruction about not talking to anyone, I also want to give you some particular instructions about the use of electronic devices and media, including social media. And then I'll explain some of the trial processes that might seem a bit confusing to you at first. There will be coverage about this case in the media, or discussions about the case in all sorts of public and private venues. And you must avoid coverage and those discussions at all costs. You must not read or listen to any information presented about this case through newspapers, radio, television, or any other sort of coverage. The reason why this is so important is that you must decide the case based solely and entirely on what you learned during the trial. If any information about a case comes to your attention other than the evidence presented in the courtroom, you should avoid that to the fullest extent possible. If you do hear, read, see, or obtain information about the case or any of the parties outside of the courtroom, do not share that information with your fellow jurors, but do tell the court-martial at the first opportunity, and we'll take care of it. You should not use electronic devices or computers to communicate about this case, including tweeting, texting, blogging, emailing, posting information on a website or a chat room, or any other means at all. Do not send or accept any messages to or from anyone about this case or your jury service. You may not do any research or look up words, names, maps, or anything else that may have anything to do about the case. This includes using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are here at the courthouse, at home, or anywhere else. All of us are depending upon you to follow these rules so that there'll be a fair and lawful resolution to this case. Unlike the information presented during the trial, if you were to investigate, research, or make inquiries on your own outside of the courtroom, we would have no way to assure that the information is relevant to the case. Also, the parties would not have an opportunity to dispute the accuracy of what you found or to provide rebuttal evidence. This is contrary to our judicial system, which assures every party the right to ask questions about and rebut the evidence being considered and to present argument with respect to that evidence. Non-court inquiries and investigations unfairly and improperly prevent the parties from having that opportunity. If you become aware of any violation of these instructions or any instruction that I give in this case, you must tell me immediately by giving a note to the court officer. You will be deciding the facts based upon the evidence that you see and hear in this courtroom. One of my jobs is to decide what is proper evidence and what isn't. Sometimes there may be a disagreement between the attorneys as to what is appropriate evidence, and an attorney may make an objection. You should not draw any inference whatsoever against an attorney or a party simply because an objection is made. If the objection is sustained by myself, that means the witness should not answer the question. Or if they've already answered the question, you must disregard the answer. And if that happens, I'll try to be as specific as possible as to what testimony is disregarded. If an objection is overruled, that means that the witness may answer the question, and you should consider the testimony as part of the evidence in this case. Now, from time to time, there may be a sidebar or bench conference during the trial between the lawyers and myself. The purpose of such conferences is not to try to keep things from you, but to make sure all proper trial procedures are followed, to deal with any scheduling issues that may arise, and to make sure all of the evidence that you hear is proper evidence. I will do my best to try to keep these to a minimum. We'll also have recesses at regular intervals during the trial day to allow you to stretch your legs and to use the restroom. However, if you need a recess, however, at any time, just let me or the marshal know by raising hands, and we'll make sure you get that break. During the course of the trial, I may have to call a recess because there are discussions about trial process that I need to discuss with the attorneys either in your absence, or I think it's going to take more than just a few minutes. If that happens, rather than have you sit there, I'll take an unscheduled recess. I'll send you out, address what we need to address, and then bring you back in and resume the trial. Again, I'll try my best to keep those interruptions at a minimum. We're now going to start with the opening statements. In the opening statements, the attorneys will give you an outline of what the case is about and what they believe the evidence will show. Please listen carefully to both sides, obviously. But as you do, remember that these opening statements are not evidence. After the opening statements, we'll proceed with the trial. Counsel for the state.
Thank you, Your Honor. Thank you, Your Honor. Good morning. April 24th, 2018 started out just like every other shift Corporal Eugene Cole of the Somerset County Sheriff's Department had worked. Before he began his evening shift, he put on his tan uniform shirt, secured the buttons of his shirt, and made sure that the pins of his uniform were securely attached to the collar of his shirt. Before he began his evening shift, he put on the creased brown uniform pants that completed his uniform. And before he walked out the door of his home to begin his watch over Somerset County, he put on the boots that he had worn so many times before. Once he was dressed, he holstered his gun, locking it in place, stowed his baton, and attached his keys to his duty belt. Ready to begin his shift, he jumped into the marked cruiser that bore his call numbers, 1312. The same truck marked with lights and sirens and insignias indicating that it was a Sheriff's Department vehicle that he had driven so many times during his career with the Sheriff's Department. Once situated in his cruiser, he began his watch patrolling the roads of Somerset County as his watch guard camera system recorded his every move. It kept track of his speed, when he turned on his lights, when he applied his brakes. It kept track of his movements through latitude and longitude. And it kept track of the time and date. But that night, Corporal Cole's watch didn't end like it had so many times before. Instead, early the morning of April 25th, when he should have been returning to his home, Corporal Cole was lying on the ground of the dooryard of 16 Mercer Road in Norridgewock. The back of his pants dirt covered. The crease of his pants near his knee now soiled with dirt and vegetation, and his boots embedded with dried mud. His issued flashlight lying on the pathway to the residence. A gunshot wound to the right side of his neck, apparent to the first responding officers. That gunshot wound was later examined by Dr. Mark Flomenbaum of the Office of the Chief Medical Examiner in Augusta. An injury that he determined was caused by a gun that was placed directly up against the skin of Corporal Cole's neck, blackening the wound entrance with gunpowder. The path of that wound was right to left, slightly downward, and slightly front to back. Corporal Cole died as a result of that gunshot wound to his neck. Now, the morning of April 25th should have been like every other morning for Kim Sorois, who lived at 16 Mercer Road in Norridgewock. But that morning, she awoke to a helicopter landing in the yard of the school next door. Curious as to what was going on, she opened her door that overlooks her driveway, and there on her lawn, she saw a fallen police officer. Immediately, she began to scream to the crowd of officers who had converged at the Norridgewock Fire Department that was located directly across from her home. Hearing her screams, Lieutenant Kevin Adams of the Department of Inland Fishery and Wildlife hastily made his way to her yard. And there he found Corporal Cole. Once Corporal Cole was found, members of the evidence response team of the Maine State Police descended upon 16 Mercer Road to painstakingly examine that scene. And not far from where Corporal Cole lay, Detective Paul White, who was a member of the evidence response team, saw and collected a 9mm cartridge, a red-brown stained bullet, and a spent 9mm casing. And while he examined the scene where Corporal Cole was found, Detective Jason Fowler of the Maine State Police Evidence Response Team searched Kim Sorois' Nissan Xterra that was parked in the driveway of her home at 16 Mercer Road. Inside the Nissan, located on the back passenger seat and floorboard, Detective Fowler found a shotgun, a holster for a handgun, a bulletproof vest, and lots of ammunition. But oddly, there was no gun that would use 9mm ammunition located with the items that he found in Kim Sorois' vehicle. It wasn't until days later, in a cabin off of the Bear Mountain Road in Norridgewock, that the gun that was used to shoot and kill Corporal Cole was found. A remote one-room cabin that had been entered by shooting through the window pane of the camp door. A 9mm spent cartridge casing located just outside the door, along with another 9mm cartridge and a bullet that was later found by the evidence response team. And once the officers made their way into the cabin, they found hidden under a rug this gun, a 9mm Ruger. And during the course of this testimony, you'll hear about the serial number, and you'll hear about how this gun functions. Now that handgun was examined by Kim Stevens of the Maine State Police Crime Laboratory. And that's what she does. She examines firearms, she examines casings, she examines bullets and cartridges to determine whether or not a particular gun was used to shoot a bullet, leaving behind the casing. Kim James examined that 9mm Ruger, along with the spent casings left behind at the Mercer Road and the cabin off of the Bear Mountain Road. And after examining the gun, the bullet, and the casing gathered near Corporal Cole's body, and the casing found at the camp off of the Bear Mountain Road, she determined that that 9mm Ruger right there was used to gun down Corporal Cole. But just as importantly as determining that the gun was used to kill Corporal Cole, she also examined Corporal Cole's shirt. And after applying chemicals that detect the presence of lead, she found exactly that. Lead on the right side of the collar of Corporal Cole's duty shirt. Kim James will testify that if lead is detected, the gun was at close range, if not at contact, when it was fired. But where was Corporal Cole's cruiser? Shortly after Corporal Cole's cruiser was captured pulling into Kim Sorois's driveway at 16 Mercer Road on the watchguard camera, this man was filmed running towards Corporal Cole's police truck that was parked in the driveway. This man, a short time later, is seen driving into the parking lot of the Norwich Walk Cumberland Farms, just a short distance from 16 Mercer Road. John Williams is captured on the watchguard, entering the store, and then returning to Corporal Cole's truck with a water bottle, later found in the cruiser, and a pack of cigarettes. He is then seen on the video footage as he backed the cruiser out of its parking spot and fled, still armed with the 9mm Ruger and a submachine gun that later was located at the cabin. And only then do the pieces begin to fall into place, because Lillian Bernier, the clerk at the Cumberland Farms, knew something wasn't right when this man, John Williams, drove into the store parking lot and entered the store, because she knew he wasn't a deputy with the sheriff's department. And immediately after he fled, Lillian Bernier called 911. But still no one knew where Corporal Cole was or where his cruiser was. The evidence will show that from the Cumberland Farms, the defendant traveled the back roads until he found a spot to hide the cruiser from detection on the Martin Stream Road. But before leaving the cruiser, he called his friend Chris Williams and told him that he had shot and killed Corporal Cole. And as a result of that phone call, Chris Williams notified law enforcement at the Cumberland Farms and then proceeded to the Martin Stream Road, where the defendant came out into the road and flagged him down. There, John Williams got into Chris Williams' car, told him again that he had shot Corporal Cole and that he was dead. And then the defendant demanded that Chris Williams give him his car and his cell phone. But Chris refused. He refused to help the defendant avoid capture. He would not let the defendant take his car, but he relented when the defendant demanded his cell phone. And once the defendant had Chris's phone, he fled into the woods, dropping a green bag, more ammunition, and his wallet along the way. But he kept the submachine gun and the 9mm handgun and enough ammunition in an ammo can to load both. But before going deep into the woods, the defendant reached out to his friends to apologize. Meanwhile, Chris Williams left the Martin Stream Road and found another officer, a Fairfield officer, and notified him of what the defendant had just told him and where he was. And the search for John Williams began. For 4 days, the defendant, still armed with the 9mm and the submachine gun, evaded capture and remained in the woods until his apprehension outside the small cabin off of the Bear Mountain Road. Now, we all have an idea of what murder is. As Justice Mullen will explain to you at the end of the case, the Maine legislature says that a person is guilty of murder if he intentionally or knowingly causes the death of another human being. Now, in Maine, murder cases are exclusively prosecuted by the Maine Attorney General's office. And as you may recall from last week, my name is Leanne Zabia, and I am an Assistant Attorney General. My colleague is Lisa Marchese, and she is a Deputy Attorney General in the Criminal Division of the Attorney General's office. And seated with us is Detective Jason Andrews of the Maine State Police. He is the lead investigator into the homicide of Eugene Cole. And during the course of this week and perhaps into next week, he will be assisting Lisa and I as we present the evidence to you in this courtroom. Now, with regards to the murder charge, it is our responsibility, it is our job to prove to you 3 facts beyond a reasonable doubt. First, that Eugene Cole is dead. And the state suspects that there is no dispute between the state and the defendant that Eugene Cole is dead. Second, that Eugene Cole is dead as a result of this defendant's conduct. And by that I mean that John Williams caused Corporal Cole's death. That means that his death would not have occurred but for this defendant's conduct. And again, at the conclusion of the evidence presented to you, the state suspects that there will be no dispute between the state and the defense that John Williams caused Corporal Cole's death. The third and final fact that we must prove is that the defendant was acting either intentionally or knowingly at the time he caused Corporal Cole's death. Now, those 2 terms, intentional or knowing, are defined for us by the legislature. And a person acts intentionally when it is the person's conscious object to cause a certain result, which in this case is the death of Corporal Cole. Or a person acts knowingly when it is practically certain that a certain result will occur as a result of the person's conduct. In this case, that it was practically certain that the defendant's conduct would cause the death of Corporal Cole. Now, those two terms, and I understand and realize that that is a mouthful, but Justice Mullen will define that for you at the conclusion of the trial. But suffice it to say that intentional or knowing are what we call culpable states of mind. They involve what a person was thinking at the time that they engaged in the conduct that they did. Now, we can't open up the top of someone's head and peer down inside to understand what they were thinking at the time that they acted. Because rarely, if ever, do we have direct evidence of the internal workings of the mind. But you can infer and may infer a person's intent or state of mind from the surrounding circumstances. You may consider any statement and any act done or omitted by the person and all other facts and evidence which indicate a state of mind. You may consider it reasonable to infer and find that a person intends the natural and probable consequences of acts knowingly done or knowingly omitted. So what does that mean, intentional or knowing? Let me give you some examples to assist with understanding those two definitions. Let's say I have a gun, and I make the gun ready to shoot. And I walk up to a person, and I point that gun directly at their neck. Not inches away, but directly up against the skin of their neck. And then I pull the trigger. And I know if I pull the trigger, a bullet will be discharged directly into the person's neck, and death occurs. Now, we would all agree that even though I haven't said a word, that we could infer from my conduct that it was my intent to cause that person's death. Knowingly is somewhat similar, but just a little bit different. But let's use that same example again. Let's say I have that same gun, and I take it off of safety, making it ready to discharge a bullet. And I walk up to a person, and I take that gun, and I place it directly up against their neck, and I pull the trigger. But this time, I don't intend to cause that person's death, but death nonetheless occurs. Now, we would all agree that it's practically certain that by pointing a loaded gun up against someone's neck and pulling the trigger, that the natural and probable consequence will be death. That's knowing conduct. Now, one thing the state does not have to prove is premeditation. And that, by that I mean that there was a deliberate plan put in place by the defendant to kill Corporal Cole. Instead, the intent to cause death can be formed in the instant before the death-producing conduct. Another question you won't have to answer, and that the state does not have to prove, is why the defendant killed Corporal Cole. Or put another way, what was the motive? What motive did he have to kill Corporal Cole? Because motive to kill is not one of the three facts that the state must prove beyond a reasonable doubt to sustain a murder conviction. But here we know there was a motive to kill Corporal Cole, because the defendant told Detective Andrews that the reason he shot Corporal Cole was to avoid returning to jail. In the weeks just prior to Corporal Cole's death, the defendant had been arrested in Massachusetts on gun charges, and he was scheduled to return to court in Massachusetts on April 25th. But he didn't want to get locked up again, and he had real concerns that he was going to be locked up in Massachusetts on those gun charges. He wanted to avoid going back to Massachusetts at all costs because he had other plans. On April 21st, 2018, just 4 days before Corporal Cole was killed, the defendant's girlfriend, Christine Pomerleau, who was driving the defendant's car, was stopped by deputies Cole and Wakeham of the Sheriff's Department while the defendant sat in the passenger seat. Inside the car, drugs were found by Corporal Cole, and Christina was arrested because she was the driver of the car. Now, the defendant knew that those drugs were his because he had been selling and using drugs for a while. And as he drove away, Christina under arrest, he started to make a plan. Later that day, of April 21st, he learned that Christina's bail was set at $5,000 during a jail call he had with her. And during that jail call, he told Christina he was going to move mountains to get her out. He understood it was his responsibility. Those were his drugs, not hers. And so began the quest to get Christina out. In the days between her arrest and the murder of Corporal Cole, the defendant sold drugs, a lot of drugs. And he was selling drugs, and as he was selling drugs, he was also using drugs. And on the eve of April 24th, he had gathered some money to get Christina out of jail. But he didn't expect to encounter Corporal Cole. Now that evening, Corporal Cole had intended to arrest the defendant for the drugs that were in the car the day Christina was arrested. And if he encountered him during his travels of his shift, that was his plan. As the defendant said during an interview following his arrest, he was mad at Corporal Cole. He told them, yeah, I was mad at him, but I didn't intentionally go out to look for him. But he did encounter Corporal Cole. And Corporal Cole foiled his plans when he told him he was under arrest for the drugs that were found in his car the day Christina was arrested. And not wanting to go to jail again, the defendant got the jump on Corporal Cole. As Corporal Cole reached for the defendant to arrest him, the defendant jerked away and caught Deputy Cole off guard. Corporal Cole lost his footing, and he slipped to the ground, muddying his pants and boots as he attempted to retreat from the defendant. Instinctively, the defendant grabbed his Ruger 9mm and pointed it at Corporal Cole's head while Corporal Cole was on the ground and shot him. And as he pointed the gun at Corporal Cole, he begged the defendant not to shoot him, saying no. But Corporal Cole's pleas were disregarded by the defendant. Instead, he fired the gun in the one area of Corporal Cole's body that's sure to cause death, his head. And he made the choice, just as he told Detective Andrews, to use the firearm on Corporal Cole. And as he told Detective Andrews after his arrest, he shot Corporal Cole that he eliminated him. Now, the state suspects that Mr. Parody, on behalf of his client, is going to get up here and tell you that the defendant couldn't have acted intentionally or knowingly because he was high on drugs. In determining whether the state has established the element of intent or knowledge, if you find evidence that Mr. Williams was intoxicated, you may consider it, because evidence of intoxication may raise a reasonable doubt as to the existence of the requisite intent or knowledge. Now, intoxication, like intentional or knowing conduct, is also defined for us. And intoxication means a disturbance of the mental capacities resulting from the introduction of alcohol, drugs, or similar substances in the body. Now, it's important that you keep in mind that while it is fully open to you to consider evidence of intoxication in determining whether the state has established the element of intent or knowledge, the ultimate question is not whether Mr. Williams was intoxicated, but rather whether the state has proven that he acted either intentionally or knowingly when he caused Corporal Eugene Cole's death. Now, as indicated, the burden of proof is on the state. That's what I meant when I said it is our job to prove those three elements to you. And the burden of proof in a criminal case is that of beyond reasonable doubt. And as I said earlier, there is no dispute between the state and the defendant that John Williams caused Corporal Cole's death. The real issue here is, did he cause Corporal Cole's death either intentionally or knowingly? So how do you answer that question? Well, you do so by applying your good old-fashioned common sense and reason. When you come into this courtroom, you don't leave your common sense and reason out on the sidewalks before you enter the courthouse doors. And when you come into this courtroom each and every day as the evidence unfolds, your common sense and reason is right there with you in that jury box. Because when we talk about the burden of proof of beyond a reasonable doubt, we are talking about common sense and reason. Or put another way, that you have a conscientious belief that the charge is almost certainly true. And if you apply your common sense and reason, you will find conclusively that it was the defendant who caused Corporal Cole's death during the morning of April 25th in the dooryard of Kim Sorois's home, because the defendant acknowledges, he admits that he is the one who shot and killed Corporal Cole. Your common sense and reason will tell you that even if he had been using drugs, he was able to identify who approached him. Not some stranger off the road, but the very man he was mad at, because Corporal Cole had previously arrested his girlfriend, Christina Pomeroy, and was about to arrest him for the drugs that were in that car. Your common sense and reason will tell you that when Corporal Cole approached the defendant, it was to arrest the defendant, something the defendant did not want to happen, because he told Detective Andrews that was the case. Your common sense and reason will tell you that when the defendant brandished the gun, he knew it was a gun and intended to use it. If you apply your common sense and reason and find that the entrance wound was blackened by gunpowder, as will be described by Dr. Flomenbaum, and that the blackening only occurs when the barrel of the gun is in close contact with the skin, then the gun that caused the injury must have been in contact with the skin of Corporal Cole's neck. If you use your common sense and reason and find that Kim James found lead on the collar of Corporal Cole's shirt, and the presence of lead will only be present when a gun is discharged in close proximity of the shirt, that the gun used by the defendant must have been near Corporal Cole's neck when it was fired. If you apply your common sense and reason and find that the casing found near Corporal Cole's body and the casing at the cabin at the Bear Mountain Road was fired from this 9mm Ruger, then it was a gun that the defendant used to shoot Corporal Cole. If you apply your common sense and reason and conclude that as Corporal Cole was on the ground begging for his life, the defendant pointed the gun directly at his neck and fired, then he must have intended, or at least knew, that death would occur. Your common sense and reason will tell you that if the defendant had acted recklessly or negligently then he wouldn't have told Chris Williams that he shot Corporal Cole and needed his car to get away. Common sense and reason tells you that if the killing of Corporal Cole was the result of an accident, then you wouldn't arm yourself with a high-powered weapon, such as a submachine gun and a 9mm handgun, with enough ammunition to load both and flee into the woods. Common sense and reason tells you that if firing the gun directly at Corporal Cole's neck was reckless or negligent, you wouldn't use the phrase eliminate him when speaking with Detective Andrews. Instead, common sense and reason tells you that when the defendant brandished that 9mm Ruger and pulled it directly at Corporal Cole's neck, that he intended or knew that he was about to eliminate him. After all the evidence is in, if you apply your good common sense and reason, you will conclude that the state has proven to you beyond a reasonable doubt that John Williams intentionally or knowingly killed Corporal Eugene Cole, and you will say so here in this courtroom. Thank you.
Thanks, counsel. Thank you. Thank you, Your Honor. Good morning, ladies and gentlemen. As you know, my name is Vern Parody, and together with my colleague Patrick Nickerson, we have the pleasure of representing John Williams, who sits here today, who you will see and hear is a completely different person than existed on April 25th. Now, you just heard a pretty extensive rendition of the facts and the evidence that you're going to hear in this case. And I think it's going to be fair to say that we are not going to dispute most or almost all of those facts. We do dispute where the gun was when Corporal Cole was shot, but you will hear me question witnesses from the state very little. There's very little dispute of what occurred on that night other than how the shooting occurred. It's easy when we see photographs and we hear about a well-respected police officer who is trying to protect the county of Somerset County and who's putting on his boots and putting on his uniform and the fact that he has a family, and there's no dispute to that. There's no dispute to that. Corporal Cole was by all accounts a good man and a good officer and well-respected. And what happened on April 25th is a tragedy that nobody can take back. But you were all vetted very closely during jury selection. And you were told, and you will be told again, that you cannot apply sympathy. You cannot apply emotion. You must consider the evidence from a business-like perspective and forget that there is, and put aside your sympathies and emotions. Now, Mr. I told you Mr. Williams was a completely different man back in 2018. Mr. Williams, you will hear, by all accounts, was using extraordinarily excessive amounts of drugs. Cocaine, heroin, pretty much anything he could get his hands on. He told people that he was smoking crack cocaine like he was inhaling air. In other words, he was smoking crack nonstop. He was using heroin. He wasn't sleeping. He'd gone days without sleeping before the shooting because of the drug use. He was just on a high. You'll see pictures of him. He weighed about 104 pounds because he wasn't eating. This was a man who was in the throes of a significant drug addiction. And you're going to hear from a physician by the name of Dr. Steinberg, who is an addiction specialist. And he treats patients who are addicts. And he sees them on a daily basis. And he's going to tell you that a person who's on drugs and doesn't necessarily appear to be incompetent, they're able to function. They're able to make decisions. They're able to get around and consciously think of things. And it's not our defense in this case that Mr. Williams was just completely blacked out and had no idea what he was doing. But as you'll hear Dr. Steinberg say, which is probably one of the most compelling pieces of this case, is that he would compare Mr. Williams' state on that extensive drug use to an animal caught in a trap. And that animal will chew its leg off to get out of the trap, not thinking about what it's going to be like with only having 3 legs. So what you're going to hear is, yes, Mr. Williams was able to load the weapon. Mr. Williams was able to make some goals to get out of there, get away. Mr. Williams could make decisions. It's not our defense that he wasn't functioning. It's our defense that Mr. Williams did not intend to cause the death of Corporal Cole. Now you're going to hear from witnesses that in the days and weeks leading up to Corporal Cole's death, Mr. Williams was acting very bizarre. He had been recently kicked out of a place where he was staying because of his behavior, his addiction behavior. He was extremely paranoid. He thought that the people he was selling drugs for from Connecticut or from somewhere down south were coming to Somerset to kill him because he had robbed money from or taken money from them. He was functioning on pure adrenaline and his drug use. And he also had court, as you heard, the next day in Massachusetts. And the man was afraid of going back to jail. On the night of Corporal Cole's death, Mr. Williams observed Corporal Cole's cruiser a few times away from where the shooting occurred, up in Somerset. And he was slumping down in his chair, in his seat. He was afraid. He was afraid of going to jail. And when Corporal Cole approached him in the middle of the night, while he's trying to get into the house that he was staying at, and told Mr. Williams he was under arrest, Mr. Williams asked him why, and said, I there's no reason to be arresting me. And then, in his intoxicated state, Mr. Williams' immediate intention was to not go to jail. So while he intentionally pulled the trigger, you will have to be convinced beyond a reasonable doubt that when he pulled that trigger, it was his intention or his knowing thought to kill Corporal Cole, to cause his death. And you are going to hear the evidence of his drug use and how that affected his ability to form the intention, his conscious objective, to form a knowing intention to kill Corporal Cole. You will hear from a specialist who specializes in these types of things. Now, you also heard about statements that Mr. Williams made to detectives. Well, the story goes something like this. Mr. Williams was on the run for 3 or 4 days. He was in a remote cabin, no food. He had run out of drugs. He was not sleeping. He had run out of drugs. He was cold. He was wet when he got arrested. And when he got arrested by 7 police officers with long arm rifles pointed at him, and then he was placed on the ground and struck by one of the officers, and then as he is escorted out of the woods, Mr. Williams felt threatened for future harm. And in fact, you're going to hear one of the first things he said to Detective Andrews was, "Man, you guys got there just in time. Those guys really beat the F out of me." Mr. Williams, by the time he got to that police station, and Detective Andrews and Quintero were very nice to him, he wanted to tell them whatever they wanted to hear. Because they told him they would give him food, which he was starving. They would get him water or juice. They would eventually let him sleep, which he asked multiple times to just sleep, sleep, sleep. And he truly believed that they would prevent future harm to him. Now, there's not going to be any evidence that Detective Andrews and Quintero threatened him or caused him any harm. In fact, you'll see the interview with Mr. Williams, and it went well. But pay attention to the interview, because when Mr. Williams tried to give his version of what happened, the detective stopped him and said, "No, we're not believing that. We're not buying that. You didn't just react and try to defend yourself, or you didn't react. John, we don't believe that. Now tell us the real story." And you'll see, that's when his story started changing in an attempt to please the officers, to prevent from further beatings and to get his needs met. This was a man who simply wanted his needs met: food, water, sleep. As the state has, as Ms. Zania has told you, the state has the burden. And again, it's the highest burden that we have in our justice system. And that's beyond a reasonable doubt. So that's not more likely than not. That's not probably. It's not maybe. It's almost certainly true. And as you consider the evidence, and as you consider what you hear from witnesses in this case, and you won't hear much dispute about what that evidence is, you will apply that standard to determine whether the state has proven to you that under the significant influence of drugs, that Mr. Williams almost certainly had the intention or the knowledge of killing or causing the death of Eugene Cole, as opposed to his actions in a high, intoxicated state, acting irrationally and not thinking it through. And then at the end of the case, we will be up here to give you our closing arguments. And at that time, I will urge you and suggest to you that the evidence you've heard will not meet that standard, and that the state cannot prove that his intoxication did not interfere with his ability to think intentionally and knowingly. And I'll ask you to return a not guilty verdict on the murder charge. Thank you.
Thank you, counsel. Ladies and gentlemen, we're now going to take a little recess a bit early in order to give court personnel often get your notebooks out. So I remind you, please just take the break for the manner intended to relax, visit the restroom if you need to. I'll try to get you back in here in about 10 minutes. Please do not discuss the case, obviously, with each other, and that's the first of many times I'm going to be telling you that. So with that, take a break, and I'll get you right back out.
All rise for the departure of the jury.
Counsel, anything we need to put on the record? Otherwise, we'll take,
Could we just approach, Ron?
sure.
On the record, counsel?
Yes.
All right.
Thank you.